In this video, I'm going to walk you through the steps of creating a will in California. I'll walk you through the steps of creating a will in California. We'll take a look at the legal requirements and also what happens if you don't have a will. So by the end of this video, you're going to have a much better understanding about how to create a will in California. And by the way, if you would like to get help creating a will in California, you can contact my friends at lawdepot.com and they'll be able to help you with creating a will in California. For your convenience, I have a link to their website down in the description of this video. So simply scroll down, click on it, and it will take you directly to their website. And with that in mind, let's jump right into it. Steps to create a will in California. Before delving into the details, let's begin with a quick checklist outlining the steps to create a will in California. Asset selection. Determine which property and assets you want to include in your will. Beneficiary designation. Decide who will inherit your property and assets. Executor appointments. Choose an executor responsible for managing your estate. Guardian selection. If you have minor children, designate a guardian to care for them if you pass away. Property manager choice. Designate someone to oversee property left to minor children. Will drafting. Create your will, ensuring it adheres to California's legal requirements. Witness signatures. Sign your will in front of 2 witnesses. Secure storage. Safely store your will and ensure your loved ones know where to find it when necessary. Why should you make a will in California? A last will and testament, commonly known as a will, plays a vital role in protecting your family and assets in California. A will serves several purposes. Asset distribution. You can specify how your assets and property should be distributed among your chosen beneficiaries and organizations. Guardianship for minor children. Name a personal guardian to ensure your minor children are cared for according to your preferences. Property management. Designate a trusted individual to manage property you leave to minor children, safeguarding their interests. Executor appointment. Appoint an executor responsible for executing your will's provisions as specified. What happens if I don't have a will? In the event of your passing without a will, California's incessancy laws will determine the distribution of your property. These laws prioritize your closest relatives, starting with your spouse and children. If you lack a spouse or children, the distribution extends to grandchildren, parents, and increasingly distant relatives, including siblings, grandparents, aunts, uncles, cousins, and your spouse's relatives. In the absence of eligible relatives, the state takes control of your property. Do I need a lawyer to make a will? While it is not mandatory to hire a lawyer to create a will in California, consulting an attorney can be beneficial in specific situations. If you anticipate potential will contest or wish to disinherit your spouse, seeking legal advice is advisable. Alternatively, you can utilize online resources like Law Depot to create a valid will while complying with California's legal requirements. Requirements for writing a will in California. To create a legally valid will in California, you must meet the following requirements. Age and capacity. You must be an individual aged 18 or older or emancipated minor and of sound mind. In this context, of sound mind means understanding the implications of making a will, being aware of the property you own, recognizing and recalling your relatives, not having a mental health disorder leading to delusions or hallucinations affecting your property decisions. Additionally, you must not use your will to dispose of property that does not belong to you. Hard copy requirement. Your will must be on physical paper. It cannot exist in audio, video, or any other digital format. Handwritten wills are allowed but are generally discouraged. How to sign your California will. To finalize your will in California, follow these steps. Sign your will in the presence of 2 witnesses. Have your witnesses sign your will at the same time as each other, either when they witness your signing your will or, if you've already signed the will, when they witness you acknowledging your signature on your will. It's important to note that neither witness should be beneficiary of the will. California law presumes that any gift made to a witness of the will was made under duress, and the witness could lose the gift if it's more than what they would have received under intestacy law. Do I need to have my will notarized? Notarization is not required in California to make your will legal. While some states allow you to create a self-proving will by signing a special affidavit in front of a notary, California permits your will to be self-proved without a self-proving affidavit. If you currently sign and witness your will, it does not need to be proven to the probate court, and there is no need for a self-proving affidavit. Should my will name an executor? Yes, it is advisable to name an executor in your California will. This individual will assure that the provisions of your will are executed after your passing. Law Depot can generate a letter to your executor outlining their responsibilities. If you do not name an executor, the probate court will appoint someone to manage your estate. Can I revoke or change my will? In California, you have the freedom to revoke or amend your will at any time. You can revoke your will by burning, tearing, canceling, obliterating, or destroying the will with the intention to revoke it, creating a new will that explicitly revokes the old will or contains contradictory terms. If you divorce your spouse or your marriage is annulled, any gifts made to your spouse in the will and any provisions naming your spouse as an executor or trustee are automatically revoked unless your will expressly states otherwise. For making changes to your will, it is generally best to revoke the old will and create a new one. However, if you only need minor adjustments, you can add an amendment to your existing will, referred to as a codicil. In both cases, ensure that you follow the same formalities used to create your original will. Can I make an electronic or digital will? While a few states permit the creation of electronic wills, California currently does not. However, the legal landscape surrounding will making is evolving, and California may consider adopting e-will legislation in the future. Stay informed about legal developments if you are interested in creating a digital will. In conclusion, creating a will in California is a fundamental step in ensuring your assets are distributed as you wish and your family is provided for in your absence. Whether you seek legal guidance or utilize online tools like Law Depot, taking the time to create a valid will can provide peace of mind for you and your loved ones. And don't forget that if you would like to get help creating your will in California, you can reach out to my friends at lawdepot.com. There's going to be a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.